What does the Constitution say about political advertising? Well, frankly, the Constitution doesn't say much about political advertising beyond sort of the traditional standards for the protection of speech under the First Amendment. In fact, the Constitution says far less about political advertising than the Supreme Court and several regulatory agencies have to say about it. When it comes to that, and to understand it, the most important thing to know about political advertising is that it comes in two forms. The first, campaign ads, are ads that are undertaken by the legally qualified candidates for office. Anyone from the president down to places where they elect local officials, down even to the dog catcher. In some places, the dog catcher is an elected position. If the ad is paid for by money that is raised in a regulated fashion by the campaign themselves, which is a legal organization, then it is one kind of ad. If not, and it is an advertisement with a political message of any kind, then it is what we refer to as a non-candidate political advertisement, more commonly known as an issue ad. And why this distinction matters is because the current state of political advertising is largely the result of a court case called Citizens United v. FEC, which was a dispute over a provision in the Bipartisan Campaign Reform Act, more commonly known as the McCain-Feingold Bill, dealing with electioneering communications, which made it, prohibited, rather, a broadcast cable or satellite communication that mentions a candidate within 60 days of a general election or 30 days of a primary election. Now, campaign ads, those that came from the official campaigns, they were not bound by this provision. In fact, the entire idea of the BCRA's electioneering communication standard was to allow candidates to have access to the airwaves in the time leading up to the election so they themselves could have a debate free of outside influence. This standard, this 30-day standard, is challenged in court by a group called Citizens United, not over a political advertisement per se, but over a advertisement for a documentary that they were marketing called Hillary the Movie. Because the movie and the name named a candidate and also showed images of her, the ads for the movie were subject to the 30-day rule during the primary between Hillary Clinton and Barack Obama. And Citizens United challenged that regulatory decision from the Federal Elections Commission all the way up to the Supreme Court. And the Supreme Court established a new standard for political advertising, which is only really a decade old as I narrate this today, that is fundamentally altered how political advertising occurs, because the ruling in Citizens United overturns much of the BCRA's provisions on issue advertising. Justice Kennedy, who wrote the opinion, a very controversial 5-4 opinion, says, in his opinion, few if any contributions to candidates involve quid pro quo arrangements, but independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. And it is against this standard where he says you can't keep non-candidate advertising off the air in the time period before an election. This itself is political speech and therefore would be defended under the First Amendment. One important question that the court doesn't resolve is whether or not issue advertising should be treated the same way as campaign advertisements, because campaign advertisements have protections that come to them from the Federal Communications Commission. Section 315 of the Communications Act of 1934 allows that candidates for the same office will have equal time, that the messages in their advertisements cannot be censored by the broadcast stations that run them, and it offers federal candidates as well as state candidates the opportunity to buy advertising at a relatively inexpensive rate. These provisions, which are 80 some years old now, were largely designed to allow candidates to have access to the airwaves for the purpose of running advertising. The discrepancy between issue advertising and campaign advertising revolves around that point, because although Justice Kennedy's opinion in Citizens United largely defends political advertising by issue groups as protected First Amendment expression, they did not extend that provision to the protections that are given to campaign advertisements. It's an unresolved issue, and one that we are certain to see come up in cases. One place that we've already seen it is in the state of Wisconsin, where the Trump campaign is actually suing a station in a small market for having run an issue ad that it disagreed with. Because issue ads are not protected in the same way that campaign ads are, the station assumes the liability for selling an issue ad. I hope you enjoyed this talk, and happy Constitution Day.